In this video, I'm going to be explaining something that you really need to know before you go into your restraining order hearing, and you really need to prepare for, which is what to do if the judge just won't listen to your side. I know that might sound weird. You should have your day in court. I have so many videos on objections that you can present and how to get your evidence in and how to keep the other side's evidence out. In fact, I have a whole course on how to prepare for your restraining order hearing and win even without an attorney. But sometimes the judge just flat out says, I'm not going to listen to your side. So let's talk about what to do if that happens and how to prevent it. My name is Veronica. I'm a domestic violence restraining order defense attorney, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to win your restraining order hearing. If that is something that you're interested in, you can find a link to your first free class down below. Okay, so let's jump right in. What to do if the judge will not listen to your side of the story. Number one, make sure that you don't stipulate to a judge pro tem. So this is really about prevention, and the next one is too. Okay, so in my opinion, how the court system treats restraining orders is that they are a nuisance. They don't make money for the court system. There's generally no filing fees. A lot of cases that are not meritorious, it's people filing handwritten documents against one another. The court system does not really care about them or respect them. And so just like small claims, many times they will assign what's called a judge pro tem to hear all the cases for the day in a particular courtroom. Now how this works is that you will show up for your hearing and you will be told, well, there's a judge pro tem today, sign here to stipulate to that. This is an attorney who's going to be standing in for the judge today. So many people think, okay, well, that's okay. It's an attorney. They're going to be able to, know what to do in this situation. So you may think, all right, well, I guess I have to sign it. Okay, so here's what that means. A judge pro tem is an attorney who works in a different area of law than whatever your hearing is about. So does not work on restraining orders. So do not go with the judge pro tem, because the judge pro tem probably does not know the law and you cannot trust that they do. Number two, okay, so you know that you're not going to go with the judge pro tem. You're not going to let this temporary judge, this attorney who knows nothing about this area of law, hear your case. So you are probably then going to have the judge who is in the courtroom that your case is assigned to hear your case. One thing that you can do, and you can learn a lot by doing this, you can prepare a lot for your hearing by doing this, is go to the courtroom in advance and just watch some hearings. Just see how the judge is. See what the litigants do, what the parties do that causes them to screw up, that causes the judge to get mad. See how much does the judge let each side present their evidence. How busy is it? How many cases are on the calendar? Look at all of this, because then you'll have a better idea of what to expect that day. And just in general, you'll have a better idea of where to go, what to do. You'll meet the bailiff, you'll meet the clerk, you'll see where you're supposed to go when your case is called. All of that is important, but more than all of that is to just see how the judges, see their temperament, try to get to know them by observing them and see what they let the parties do. See what annoys them. See what kind of questions they ask and if they ask a lot of questions. All of that is going to be so important, and I can only prepare you so much via my YouTube videos, via the course that I teach on how to win your restraining order hearing. I can teach you general concepts, and I can teach you, from start to finish, how to present your evidence, how to object to what the other side tries to present, what the judge is looking for. I can teach you all of that, but I cannot teach you about your specific judge. And it doesn't always necessarily matter, but some judges do things a little bit differently, and they are supposed to, by law, allow you as the petitioner or respondent to present your evidence. Number three, if you see that the judge is not letting petitioners or respondents, or maybe just respondents, present much of their evidence, giving them very, very, very little time, and by that I mean probably less than 5 minutes to present their evidence, you might want to submit a written response ahead of time. Now, generally, for respondents, I advise against this. I don't like my clients typically filing a written response as a respondent, because you don't have to. Respondents don't have to in the state of California. So if you do file a written response, then you're just giving the petitioner notice of everything that you are going to present potentially. But if you know that the judge is not going to really let you put in much testimony, is not going to let you present much evidence in court, you might want to consider that, yes, the petitioner will see your side in advance, and it may or may not matter depending on your case, but the judge will also see it. Number 4, you're going to have to be a bit assertive. A bit. Some of you, maybe I need to help you be more assertive and sort of, boost you up. Some of you, maybe I have to tone you down. It depends on you. But you're going to have to be a bit assertive, but polite, and say something like, Your Honor, may I briefly present my evidence? If you have evidence and the judge seems to be just sort of steamrolling through the hearing and not giving you a chance to present your evidence, then that is what you say. Your Honor, may I briefly present my evidence? Depending on the judge, and assuming that the judge doesn't tell everybody in an announcement ahead of time not to do this, you can even sort of like raise your hand like this to hopefully get an opportunity to speak if there is not one. Make sure you don't interrupt the judge. Let's go to number 5. So number 5 is that you should know that if you're the respondent and the judge is discouraging you or doesn't want to let you present your evidence, it's not necessarily a bad thing. So I've had cases where the other side has presented their evidence and their evidence was horrible. They presented almost nothing or didn't even come close to meeting the legal standard. And so in those cases, what I do is I really try to look at the judge and read the judge, because I can put my client on the stand. I can have my client testify, maybe screw something up, maybe inadvertently give evidence that makes it seem like they did whatever they're being accused of, make it seem like there should be a restraining order. Maybe the other side asks questions and cross-examines them, the judge asks questions. I mean, it's basically a wild card, right? And for you, although you may not view it the same way that I do, where I'm like, I have my client here, I prepared my client the best I can, but I can't change their personality. I can't control them like a puppet. So to me, they're always a wild card. You may not view yourself that way, but whatever you're going to say, could potentially be misinterpreted. You never know. So in those situations, I try to read the judge and figure out, should I have my client testify at all? And I've had cases where I prepared my client extensively as the respondent to testify, and I knew my client would be upset with me if he or she didn't testify and we lost. But the other side really didn't meet their burden. And sometimes the judge will say something to me like, did you want to put on any evidence? Did you want to have your client testify, Miss Barton? Or should I make my ruling? Something like that, where it's sort of a clear signal to me that there's no point in wasting the court's time, which is a signal to me that they are already potentially going to rule in my client's favor, and that they hope that I don't waste more of the court's time by having my client testify. And for me, since I can then eliminate the risk of a potential loose cannon, and it's not saying anything against any of my clients, but you never know, especially in these restraining order cases. People get really emotional. People say unexpected things. If I can avoid having my client testify and win anyway, of course I would prefer that than risk having my client testify and then losing the thing. So it's not necessarily a bad thing. Of course, there's always the possibility of being wrong about reading the judge. There's always the possibility that you could misread the judge and the judge really means, their evidence is so strong. Is there anything that you could possibly say? But I've never seen that, not just with my hearings, but I've never seen that where when the judge says something like that, they're saying, is there anything you could even possibly say, respondent? Throughout the hundreds, maybe thousands of hearings that I've seen. Why there are so many is that when you do these restraining orders, you end up, especially if you are an attorney and they know that your case is going to take longer, you end up sitting in the courtroom for a very long time watching many of these restraining order hearings, watching what people do that causes them to lose, watching what people do that causes them to win even when they're representing themselves. And that's one of the reasons why I'm telling you to go and watch the hearings with the judge, kind of get an idea of how these things go, what the judge is looking for, what people say to screw up, because I give a lot of tips here, and some of them are from cases that I personally have had and advice that I give to my clients and things I learned from law school or by being a trial attorney for criminal cases. Some of it is because I just watched so many of these hearings just waiting for my case to be called instead of going into the hallway or working on my laptop. I watch. and try to see if there's anything that I can learn from my clients or that I can learn and teach you here. And look, if you are interested in representing yourself at your restraining order hearing, or even if you do have an attorney but you're watching these videos and maybe you're a little bit nervous, I encourage you to at least get your free first class in Defeat the DVRO. That's the course that I teach. You can go to defeatthedvro.com. You can also go to the link in the description box below. In the free first class, you're going to learn more about what the judge is looking for, and also get an idea of like what I teach in the course, which again is everything you need to know to win your restraining order hearing, to really knock it out of the park, even without an attorney. If you did find the video helpful, please don't forget to like, subscribe, and ring the bell.